Yeah, and I think he probably thought that Taylor would be, kind enough to, offer some to her brother. But that's for her to decide. That's not for the will and everything to decide. And she may have had some animosity towards her stepmom, too.
Yeah, notoriously. Yeah, that's I think, probably something that we can count on.
Yeah.
Life's Third Act is a podcast dedicated to helping you get the most out of your retirement. Sponsored by Tucker Allen. Here's Attorney-CPA Joe Cordell.
Welcome. This is Life's Third Act, and we're continuing the conversation that we left off with. For the introduction of that, go back to the beginning of the previous episode, but I think you'll enjoy this discussion. Now, that affirmative statement will preempt laws that relate to pretermitted spouse. Yeah, you have pretermitted spouses as well as children. And all that means is that, you had a will, you got married later, so you weren't thinking about that person. So what would you likely have intended when you've died and not updated? And so the law has a default position on that. With children, it's more common that you have estate planning in place, additional children come along, you've provided maybe for your other children, and so what is the court to think you would have done if you've died now and you have children that were born after your estate planning was done, but you didn't make a provision for them? So there's a default position on that, and it's called a pretermitted child or pretermitted spouse. And generally, the default position, there's some variations on it from state to state, but for the most part, it says that look, if you provided for your other children and you've not given any indication that you wanted to exclude later children, then you probably would have included those children. But most do not give those non-included children a full share. Most give them a smaller share based on some complicated theories I won't get into. It's not an unreasonable assumption. So in this case, if it were determined that he consciously excluded this child, that it was very deliberate, that he knew what he was doing, for example, that he knew the child was coming and he had opportunity, perhaps he made statements to others, if there's any evidence that, coupled with the provision he had in his will, specific provision in his will, I don't want to include anybody else, then that would override what would otherwise have been the default position to give something to the child. So that one could argue the evidence, is pretty strongly in favor, but yet all of us think, I'm thinking, I bet you're thinking, but no, why would he deliberately exclude a child? But on the other hand, if he knew the child was coming, coupled with the language I just described, and he knew he had put that language in the will, and so here he is dying the last 6 months of his life. He knows there's a child, we assume. Mm-hmm. I didn't see testimony on that, but
yeah, I didn't either.
We have to assume he knew the child was coming. So let's assume he knew the child was coming. If he didn't, there's a better argument, incidentally. So maybe that's the case. But I tend to think that he knew it. We didn't get the transcripts from the hearings, so we don't know what some of the witnesses testified to. There were hearings on this. This litigation went on. Another lesson here, don't invite litigation in your estate planning because you either pay lawyers or you give money to your heirs.
Everything you build for you and your family deserves protecting. All of those important assets you have worked so hard to acquire and enjoy, you want to make sure they're handled with care. At Tucker Allen, our attorneys will customize an estate plan that will work for you and your family's goals and needs. Tucker Allen, estate planning, probate, and trust administration. Visit tuckerallen.com.
In this case, if he knew the child was coming and he knew he had prepared this will in which he had specifically said, don't give anything to anybody else, would he not have then scurried to fix it? So part of me is thinking, why would he possibly want to exclude his child that he knows is coming? No father would do that. And then other part of me thinking, yeah, but he knew the child's coming, and he had this language that isn't usual. You don't always include that language. He specifically said to his lawyer a year earlier, didn't know this child was coming, granted, but he said to his lawyer, I want to specifically provide, because his lawyer put a sentence that is not automatic in a will. He put that in there. So it was intended to override all the default rules that kick in when stuff comes up that legislatures over time have figured when this has happened, this is generally what people really would have liked to have done. So we're going to override what this would appear to be because that's what most people would want. And there's no better example than this pretermitted children or spouse.
That makes me wonder if he was nervous about having like any children he didn't know about from his previous marriages.
That's exactly.
Yeah.
And that's probably right. As a matter of fact, I think you've hit the nail on the head. I think that is probably what he had in mind. Incidentally, do we know about this child in terms of his being the father?
And that's what I was just thinking about too. I was like, well, maybe he thought it wasn't his. And maybe, I mean, his life was really private.
Whoa.
Yeah, I know, now we're down a whole rabbit hole.
But it's an interesting rabbit hole. I didn't think about that.
Yeah. I couldn't find a law on his relationship with his daughter. I'm assuming that they were like, okay, and they were close. But again, I don't know, just the person that he presented himself as, maybe he wasn't the most, I hate saying this, but maybe he wasn't the most present father. Like he provided in the ways that he could, but he wasn't, Yeah,
he wasn't dad of the year.
And so maybe just thinking like, Sherry will take care of this kid.
And let's assume, though, that was eradicated, that suspicion later when the child was born. But your point is still well taken. What did he think? Mm-hmm. Did he think that possibly, it wasn't his?
Yeah.
So we'll tell you how this comes out. It comes out to where they have a hearing. Ultimately, the court decides that, we're going to conclude that this is a child that he did not specifically intend to exclude. Despite his statements in the will, he didn't know the child was coming at the time. The court concluded, which there would be a lot of pressure to do. I mean, I think that the bar would have to be pretty high that he was aware and intended to exclude this child. And I'm not sure the arguments we've made so far were probably enough to cause the court to override what is the default position. But just so you know, generally as to all of the rules pretty much as they govern the probate estate or assumptions about inheritance and claims of heirs, et cetera, they're almost all default. Intestacy laws, those are laws that govern if you die without a will. That's default, meaning you can prevent that by having a document. Mm-hmm. So that you'll find that's the case of at least 80% of these rules. And in this case, it would appear that he had overridden the rule, at a glance. But he later had a child, so even though he had written, it doesn't matter. If I've not changed this, if you were a literalist, you would say, look, he wrote a will and he said, if I don't change it, nobody gets anything.
Yeah.
And then you end up saying, I'm going to give it to somebody, give it to this child because he didn't know. So that is, though, I think judges would probably feel a little sympathy.
Yeah. So now my question is, if there was no suspicion in court, because, nobody probably knew what was going on inside their walls of their home, if there was no suspicion in court that it wasn't his son, would they have DNA tested?
And I'm guessing that was done quietly.
Yeah.
I would say that's the sort of thing that would make it into the court records. Because it would just taint his name, and it would taint even the daughter.
Yeah.
So Taylor wouldn't want to be on record as demanding that, and nor would I think that those who wanted to protect his name would want. So I would say they satisfied themselves on that. Otherwise, Taylor probably would have gone out on a limb if she had thought.
Yeah.
So let's assume it was his child. I think we can. And another force that's at work here is there's a lot of money. I mean, if there was less money, I don't think that courts would have been quite as accommodating. And another thing is that the child's mother, not Taylor, but it was Cheryl, hired a lawyer his name's Adam Streisand. Mm-hmm. And this guy is famous for across the country. I mean, he's been involved. He was with Loeb and Loeb at the time. Now he has his own shop, I think. But he's really good. I mean, one of the top litigators in the country. He's been famous in a bunch of litigation involving professional athletes, famous people in Hollywood. He's represented owners of sports teams involving billions of dollars. This guy is he's notorious for being a very aggressive, good lawyer. He represented Cheryl, meaning the child. Cheryl, remember, does not personally have a claim. She's the one who doesn't have a claim, but she's going to benefit.
Yeah.
I mean, if this child ends up with half of or some substantial portion of $175 million, she's going to have a better lifestyle, because if you give the child a nice home, nice things, just trust me, whoever the guardian is of children who are rich, they live nice lifestyles. There's just a lot of judgment calls that err on the side of the caregiver. Now, I will say in this case, though, that this $175 million, the court could have gone a couple of ways. One scenario would have been that they would conclude that the child had a claim to 50-50 interest. And that would be based on the idea that there was an actual intention to fully include the child, and there was, through some failure, through his perhaps cognitive degeneration toward the end, and maybe the will wasn't valid, depending on the circumstances under which it was drafted. I mean, there are scenarios where you can kind of throw out those provisions, and that opens the door for an equal distribution. But the chances of that argument succeeding was very little. So I think that what Adam Streisand decided to do is to simply fight the battle for the share that the statute would give, what ended up being a third, not a half. So I think Adam Streisand fought that battle because he knew it was a battle that was winnable, and it was. So this child, John, ends up getting 1/3 of whatever the estate is. One of the things that's troubling about this, coming back to the issue of taxes, because it created a sense of urgency with the estate, and I really believe it created an opportunity or circumstances where the assets didn't yield the amount that they otherwise might have. The way that taxes work is generally you owe taxes 9 months from the date of death. I mean, there are a few exceptions, some hardship scenarios. If you own a farm, if you have a business, you can possibly qualify for a payout period with a certain rate of interest, but it has to be a certain type of business. It has to be a business that you own the substantial portion of. There are various criteria that have to be met. In other words, for the most part, you can believe that if you die with a lot of money, it's not something you someday pay taxes. Mm-hmm. You have somebody knocking on the door for 40% plus within 9 months. So it's not unusual to hear that people who have a lot of money, a lot of assets, but very little liquidity are selling stuff at bargain prices because they're trying to meet this deadline. The penalties for delay are substantial. So you can end up paying north of 10% penalties for the period that you're delaying. And the mountain just gets higher for you to get past this debt problem with the IRS. So in this case, the art was auctioned. It did bring in
around
a good
$100
price.
million, yeah.
Yeah. Was it around 100 total?
Yeah, I believe so.
So $100 million. But I just wonder, I mean, again, I think this may be a situation where we have somebody who he loves his kids, doubtlessly, but I didn't come across evidence that, as you suggested a few moments ago, we're talking about one child that he knew about, 2 children he knew about, we'll assume. One that he, age 20, doubtless he had been around a lot, but I just didn't see, as I read articles, nor did you, that he was, it was front and center in his life.
Yeah.
And I don't know if this was the third or the second marriage. It goes back a while.
Mm-hmm. I believe she was the third marriage.
Okay. So it could be that, he's suffering. He has cancer of the throat. Life's not pleasant. It could be that he's just not focusing on, he figures there's enough for whoever, there's enough, and he's moving on. And I think that there was just he wasn't engaged in trying to maximize the value of his estate. Among the things that might have been done was to think more about the art collection. We should take a few minutes and talk about his incredible devotion to collecting great art.
Yeah. Yeah, he spent a lot of time collecting art. He had, Pablo Picasso, Jasper Johns, all kinds of
Liechtenstein.
Yeah, Liechtenstein. Yeah, all kinds of just 20th century art, and he was obsessed with it. He would travel all over the world to pick it up. And his daughter Taylor was like, that was part of his DNA. That's what made him. And a lot of people didn't know that until after his death, just because he was so private about doing it. But I mean, to have 100 million in sales, and they didn't even sell the whole art collection. So to have just 100 million in sales alone from the art collection can only make me imagine what all he had. And it all just went away.
And I know that some of that urgency to sell was to meet the demands of the tax man. And there could have been planning to, as I said, avoid that. And in this case, if he were, we know he was, very committed to his art, to that art collection, which he really just displayed for himself in his home for the most part.
Yeah.
That's many of the art of the most expensive items in the collection had been displayed in his home. Mm-hmm. Doubtlessly, the insurance premiums for that were huge.
Yeah.
So he was on the board of the Los Angeles Metropolitan Art Museum. Mm-hmm. And I've not been into that museum, but I'm sure it's huge, and I'm sure that's really big on 20th century artworks, which seemed to be his interest largely. For him to be able to have made a gifts or donated that in some fashion, and he could have even done it in ways that would have yielded some money over time to his children and still taken a tax deduction. So there are lots of ways to structure that. Some people will simply give a deduction where maybe there is on the front end a period of time when cash will be paid and then it'll stop, or it can be paid on the back side of the deal. So there are a variety of ways to make charitable gifts through trusts that would have allowed him to know that his collection is going to be displayed in a manner that he wants. And the wonderful thing about that is you get to specify. So if these great works of art are like children, which for some people who love art, they are, you get to say, I want these to be together. You can have a gallery named after you. Maybe he didn't care about that. But still, I can think of so many ways he could have assured that this thing he cared a lot about, kind of lived on in a way that it did for him.
Yeah.
And it would have been a huge benefit from a tax standpoint.
Yeah, and I mean, 2 questions on that front. So first, do you think there was a specific reason they sold the art first instead of, say, one of his houses or anything like that? Do you think it was just the liquidity of it? Yeah,
I think it was the liquidity, definitely. And I also think it was that the art was the thing that was least important to.
Yeah, that's true.
To many of them. I think they had a connection to the real estate that they didn't have to the art.
Yeah, and then as I was asking you earlier, if he had put that all into a trust, but he still ran into all of those tax implications, how would they have funded it? Would they have just sold a house at that point or anything else?
So he could have, as he acquired these properties, now this would have required a little more planning than a year before, but if he had known, as he has for decades before his death, that he's going to be wealthy, and so he's buying this nice art over all this period of time, to have gone ahead and transferred it into an irrevocable trust to make a gift when its value was much less. And there are even, little tactics you have where you maybe maintain control of 1% or 2% of something, and it pushes the value way down because of loss of control, so that the gift ends up being worth far less. So you get to transfer all that. Once it's transferred, except for any gift tax that was due at the time, which remember, it's worth far less for a lot of reasons. It's old, meaning it goes back a long ways, so you got appreciation, but also because you assured it was discounted in terms of using another entity. So that would have saved, who knows, because you wouldn't pay any more taxes. It's done. So he would have come to this, and over $100 million, there would have been taxes that he paid at the time, which would have been easy. And so now when he passes away, it's done. There's no taxes due from that at all. And there are other things he could have done to minimize the tax hit for his loved ones. I keep coming back to the idea that I think you and I both agree, our sense is that it just wasn't important. I mean, he didn't care that he was paying the taxes, and his kids still have lots of money, and he probably wouldn't have minded this other child getting it. I just think that, he probably, it wasn't number one on his mind as estate planning during his last year.
Yeah, and I think he probably thought that Taylor would be, I don't want to say like kind enough because it's her money, it was willed to her, but kind enough to, offer some to her brother. But that's for her to decide. That's not for the will and everything to decide. And she may have had some animosity towards her stepmom too.
Yeah, notoriously. Yeah, that's I think probably something that we can count on.
Yeah,
is that there wasn't a close relationship with Cheryl. And that really is a little bit of one of the big picture takeaways when we talk about this case is rich or poor, when you have a blended family, when you do your estate planning, you need to think about these things. And I do think that the reasons that the language provided that any other claimants were not to have it is that he didn't think he would have any other claim. He didn't think that he'd have an actual child. So he thought there would be other children come along, as you were describing.
Yeah.
I think that was the motivation, is that people pop up and say, hey, I'm an heir of wealthy people. And if that's the case, that may be very well what the court believed, is that had he known, but the question still remains, why didn't he do it?
Yeah.
Since he did know, why didn't he change it? And, he was pretty sick. So that may be the explanation. So you speculate like we do, because we these answers we don't know. And just like we don't know some of the details of what was in the trust, none of that is published. All we know is what people have told us, and people in the family have told others. So I think, though, that one of the lessons here is when you have a blended family, you've really got to put it together well. And another lesson is, are you going to care about taxes? And keep in mind that or anything, quite frankly, toward the end of your life, keep in mind that your capacity to take care of business, quote unquote, may deteriorate. And I suspect with him it did deteriorate. His interest deteriorated. He may have been in pain, and throat cancer is not a good thing to die of. And so, the time to really plan and to plan well is to do it prospectively, where you do make some assumptions about the future, but that's okay because you can change it. But to start your planning early, this was a year before, and as we suggested, we think it's probably after a diagnosis. But if planning had started at a time when he knew he was going to have significant assets, however significant that would be, it would be significant. And that would take us to the 80s. And, to have done planning then, even in the 90s, any time in the 90s would have been better. That he is thinking probably would have been better. His motivation would have been better. He could have made any changes he needed to make over time. He did go to the trouble in 2005 to create a prenup agreement. That was the right thing to do. Apparently, he did have some reservations about that relationship, I'm going to suspect.
Yes.
And it may not have been great as he left. Otherwise, I'd want to be sure that he gave her something significant for 3 years. And we shouldn't believe that he didn't just because he didn't in the will. It could be that in the trust, the living trust that he created, the revocable trust, did have a provision for her, and I'm guessing it did.
Yeah.
So that I think that the sooner you do your planning, the better. It also allows you to be able to take advantage of opportunities better. It's hard at the 11th hour to be able to plan in a way that you don't end up wasting a lot of money. I mean, to have of $175 million to have, and I'm guessing I don't know the exact tax bill, but it could easily have been $70 million. I mean, it's pointless to have that much go to the federal government, where I think you might agree with me, we can be sure much of it will be wasted, than versus you giving it to people and causes you care about. And furthermore, you get to give it to them knowing that half of it is a gift from the federal government, because it would otherwise have gone to them. So it's another thing that makes charity easy, when you know that every dollar you're giving, really it's only half of that dollar that you're giving, because otherwise the other half is gone. And we know he cared about art, and I just wonder about, and since he was on the board of this organization.
Yeah.
That's really surprising.
That's really strange.
Because
to
board
me.
members are expected to give and
Yeah.
give big. It's kind of an assumption for charitable organizations. And maybe they thought that there would be something in that will for them.
Yeah, and he didn't even leave, he wouldn't even have to leave the art, but just like a donation in general. It's very strange.
But appreciated art might have been a good opportunity. But
Yeah,
anyway, so interesting person, super talented,
very.
incredibly disciplined artist who produced some really great things, and it's a shame he died. But 66 years old. I'm 65, so naturally I think that's way too young to die. But,
It is. It's way too young to die.
yeah. But anyway, so I know a lot more about him now than I did before the show, thanks to Marlea. So Marlea will continue to provide us interesting cases and events, lives to study and learn from, lives and deaths. So this has been another episode of Life's Third Act. Till next time, take care.
You've been listening to Life's Third Act, a podcast for thriving in retirement, sponsored by Tucker Allen, your estate and elder law advisors. Each week, we discuss topics and answer questions to help you better plan for your future. For more information, visit tuckerallen.com. Subscribe and listen again next week for another edition of Life's Third Act. The choice of a lawyer is an important decision and should not be based solely on advertisements.